Hello everyone, welcome to Ekam Academy. Today we're going to discuss about Supreme Court's big verdict with respect to legal immunity for legislators in terms of bribery and corruption cases. So it made a landmark judgment overturning the previous judgment given in 1980s. So we'll be looking into the details of the previous judgment, why it was given, in what context it was given. Later we'll also understand what is the reason why Supreme Court has reverted back or it has overturned the earlier judgment, and we'll also know about the concept of parliamentary privilege in which this issue is involved or related to, and also we'll understand many more things like what are the aspects of legal immunity for the legislators and what is the background why this case was again challenged. All these things we'll know as part of this video. So here, before we start, you need to know today Supreme Court in 7 judge bench verdict. Okay, so all judges have unanimously gave a verdict that there won't be any immunity. Immunity means some type of privilege or right will be there from legal proceedings. Okay, that is you call as immunity. They will not enjoy any immunity means there is no bar that these MLAs or MPs will be protected in case if they have taken bribery or corruption as in the official post. Okay, so this is what the Supreme Court has given the verdict today. So what is the background of this verdict means? For that to understand, you need to go back to the history and we need to understand what is this 1988 PV Narasimha Rao case. Okay, before that, you just know cancer, right? So cancer, that is the most dangerous disease. But if you see in India, most of the persons have equated corruption with cancer. Okay, and even some famous personalities also have said corruption and cancer are the same, but cancer will like it will affect the body and the cells, but here corruption is a cancer that eats away the citizens' faith in democracy. That is what so many people has opined. Okay, so it is most often equate cancer that is eroding the faith in democracy. And according to our first Prime Minister Jawaharlal Nehru, he said corruption and bribery are the two things which are violating the nature of democracy and freedom. So, corruption and bribery are against the democratic principles and freedom. That is what our first Indian Prime Minister Jawaharlal Nehru has opined. So, now we'll understand what is this PV Narasimha Rao judgment or PV Narasimha Rao case in which Supreme Court has first time given legal immunity to the legislators. Okay, so this case is in 1988. Okay, for this to understand, we need to know when the PV Narasimha Rao sir is in the government or he is enjoying the majority. So because of some reasons, there is no confidence motion that was initiated against PV Narasimha Rao sir. Okay, no confidence motion was initiated. So in case of no confidence motion initiated, it is a duty of the government to show that they have the confidence of or on the floor of the house they should enjoy the majority. Then only they can sustain. So what happened in this particular case is there are some allegations that some a member of parliaments, okay, they were bribed to vote in favor of the government, and this was challenged subsequently in the Supreme Court. Okay, so this is what the case brief facts. Okay, before proceeding further, as we have referred to no confidence motion in the recent context also, there is so much of current affairs we have seen with respect to no confidence motion, right? So in this context, you need to know again, when we are referring different things, you need to refer those also in static parts, right? When we are discussing about no confidence, you should understand what is the meaning of no confidence motion. If you have seen Article 75 Clause 3 of Indian Constitution says the Council of Ministers shall be collectively responsible to the House of People, that is Lok Sabha. That means they are collectively responsible to the Lok Sabha and individually responsible to the President. That is what you know. But in case if they are not enjoying the majority of the Lok Sabha, then what is the option they have? They have to resign. Okay, that means there is clear verdict that in a clear mention in the Article 75 Clause 3 that they can enjoy the power or they can only be in office as long as they're enjoying majority in the house. So this is what no confidence motion. Okay, that means in case if any of the member of the Lok Sabha, if he feels that the government is not able to enjoy or is not enjoying the majority, then he can initiate no confidence motion. Can he alone initiate no confidence motion? Means no again. Okay, so at least 50 members of Lok Sabha should support his motion. Okay, so when any member feels and he wants to initiate, along with him at least 50 members should sign and they have to give a resolution that we want to initiate no confidence proceedings against the government to the presiding officer of the Lok Sabha or lower house, that is the speaker of Lok Sabha. Then what happens? 50 members, they have to submit a motion, I told you, but they need not mention any reasons for that initiation of no confidence motion. Okay, reasons are not at all required. Just they have to initiate with the support of 50 members. And do remember, this is can be initiated only in Lok Sabha. And if you see, is there any mention in the constitution with respect to no confidence? Means no. There is no mention about no confidence motion in the constitution. Only the rules of Lok Sabha has mentioned about this no confidence motion. Okay, so this is what you know. In case if no confidence motion gets passed, that means with what majority? Majority of the members of the house. That means 50% plus 1. If this majority, with this majority, if this is passed in the Lok Sabha, then the government has no other option but to resign. Okay, so that in that way it is very important and it is a very crucial thing for the government. Okay, in case of no confidence motion. The same thing happened at the time of PV Narasimha Rao tenure also. So when he was the prime minister, there is one initiation of this no confidence motion. So to secure the majority or to secure the support of the individual MPs, there are allegations that some members of parliament were bribed to vote in favor of this no confidence motion against the PV Narasimha Rao tenure. Okay, at that time when this case, okay, so when it reached to the Supreme Court has clearly given a verdict. At that time, these are the constitutional matters, right? Constitutional bench means which consists of minimum 5 judges. Okay, minimum 5 judges. At that time, this 5 judge constitutional bench has looked into this particular case of bribery, and in its verdict, 3:2 verdict. Okay, that means 3:2 verdict out of 5 judge bench. They have given that a verdict that the legislators, that means even MPs or MLAs, are immune from legal proceedings. That means in case if there are some allegations that the persons are bribed or corrupted, they cannot be arrested or they cannot be punished for this particular ground. That means they enjoy legal immunity. So that is what the major verdict given, because 3 judges have given in the favor of this, giving legal immunity to the legislators, and 2 members have opposed. Okay, just remember 3:2 verdict. Then what happened? Then another case happened in 2012 in Jharkhand. Okay, so in 2000, the year of when Jharkhand was created from Bihar, right? So in 2000 it was created, and subsequently what happened in 2012 Jharkhand Assembly. There like not in Jharkhand Assembly, but there are Rajya Sabha elections, and Jharkhand Assembly members are voting in the particular elections. Okay, for the seat from Jharkhand. So then what happened? To vote in favor of one Rajya Sabha member. Okay, there are some allegations that one MLA of Jharkhand, that is Sita Soren, she was involved in bribery, in offering bribery to an independent MLA. This is what allegations made. So at the time of the allegations made, CBI has filed a case. Okay, so because this Sita Soren, an MLA, she has bribed another independent MLA, because in Rajya Sabha elections, okay, who will elect these Rajya Sabha members means against the member of legislative assemblies only. To secure their vote, it was given, like it was said that this girl or this woman or this legislative member has bribed another independent MLA to vote in favor of their party in the Rajya Sabha elections. Okay, so based on this, CBI has filed a case. Then what did this case what happened after this case means, this Sita Soren, so the matter went to the Jharkhand High Court. What did Jharkhand High Court said? Jharkhand High Court said we cannot quash this case. Okay, so CBI has filed a case and Sita Soren want that case to be quashed. Okay, so what did Jharkhand High Court say? Jharkhand High Court refused to quash this particular case against Sita Soren, which was filed by CBI. At that point of time, when this was not, it was not in favor of her judgment or in favor of her, then she went to the Supreme Court of India asking to review this particular case. Okay, so against the CBI decision of filing a case, she went to Supreme Court. Then what Supreme Court said in this particular case? Supreme Court said, as the judgment in PV Narasimha Rao case with respect to legal immunity and bribery, it was given by narrow margin, that is 3:2 only. There is no clear verdict also. Okay, clear verdict is there, but still narrow margin in the verdict is there. So it said, as it is very, corruption in legislative aspect is very important, and it is having a substantial public importance matter, right? So as it is is having public importance and all. So they said we wanted to refer it to the larger bench, okay, referring it to the larger bench. At that time, 5 judgments, no, then larger bench means, 7 judgments. So in 2023, this matter, okay, again was before the Supreme Court. At that time, the present CJ, okay, DY Chandrachud, so he has referred it to the 7-judge bench, and today itself, the 7-judge bench has clearly given a verdict overturning the PV Narasimha Rao judgment that these legislators, that means MPs and MLAs, they will not enjoy any legal immunity. That means in case if they're part of any bribery and corruption related aspects, for any for speaking anything in the parliament, or for voting in the parliament, okay, for any act they do in the parliament, they are not having any immunity. So that is what a clear verdict. That means previous judgment given in PV Narasimha Rao case was overturned now by the Supreme Court today. So this is the entire case about. In this context, we are going to look into what is the previous case and what are the parliamentary privileges available to the members of parliament and other things. Okay, so now let's see what are the main points of discussion as of we have gone through brief facts in. Okay, so here you can see the points of discussion of this video, or Supreme Court ruling in the with respect to legislative immunity on bribery. Okay, so why it is in news, we have seen PV Narasimha Rao versus State 1998 case and 7-judge bench verdict. We will understand into further. Okay, what did the Supreme Court say in its verdict mainly, and what are the things it have mentioned, and what is the concept of parliamentary privilege and way forward. Okay, so if you see this syllabus falls under GS paper 2 in mains, that is Indian Constitution and Parliament especially, okay, polity. So then why it is a news, as I have mentioned already, Supreme Court today itself, okay, on Monday, it has overruled means the previous judgment which was given in 1998 PV Narasimha Rao judgment in with respect to JMM bribery case. JMM bribery means Jharkhand Mukti Morcha, okay. So with respect to that bribery case, the Supreme Court has said members of parliament or state legislature, that means MPs and MLAs, are immune from prosecution for accepting this. That means in this particular case, they said they have immunity, but now Supreme Court said it has overruled. That means they don't enjoy any immunity further. Okay, that is why it is in news. So now, what is this particular case about 1998 PV Narasimha Rao case? As I told you, PV Narasimha Rao case is 1993 Jharkhand Mukti Morcha bribery case also we call. In this case, the Shibu Soren, okay, so along with some of the MPs were accused of taking briberies to vote against the no confidence motion against the PV Narasimha Rao government. Okay, so after these allegations, it went to the Supreme Court, and Supreme Court has quashed the case. So it said against these persons, it quashed means there is no case filed, and so they said these persons enjoy immunity under Article 105 Clause 2. What is Article 105 Clause 2? It is parliamentary privilege. Okay, so there are collective privileges and individual privilege. We'll understand how. Okay, how these privileges will be there to the rescue of the legislators. Then we'll understand what is this Article 105 Clause 2. So what is this reading? No member of parliament shall be liable to any proceedings. That means no MP can be legally, okay, so they will not be arrested or they cannot be sentenced to any punishment for anything said. Means if anything is like delivered in the speech, as part of the speech by these members of parliament, or if any oath they have given in the parliament or before any committee also, not only in the parliamentary proceedings but in case of any parliamentary committee also, they will not be liable. Okay, so that is what you have to remember. And in any report also, or papers or vote, anything also, that means why this is given, in case if you're saying if you're not providing this immunity, they cannot function without their fear or favor. That is what the Supreme Court has opined. Okay, so to ensure their freedom of functioning and without any fear and favor, this immunity is necessary. That is what Supreme Court has opined in PV Narasimha Rao case. Then what is this Article 194 Clause 2? The same thing like 105 Clause 2, which is applicable for the members of parliament. This 194 is applicable to MLAs of the state legislature. Same provisions, right? Okay, so just the difference is MPs 105 and MLAs 194. So the members of state legislature shall be liable shall not be liable to the proceedings in case of anything said in or wrote in the parliament, on the legislature or any committee. So for anything, okay, to function without fear and favor, they have to require this immunity. Then why it was referred to the 7 judgments, already I told you. Okay, so after this judgment, what happened? Sita Soren case happened in 2012. Okay, so to re-examine the exact thing, so it was referred to the Supreme Court, and Supreme Court has to examine whether these things are very important, okay, or like to ensure the purpose of 105 and 194, is it essential that they have to be given that immunity or not? So this is a question before the Supreme Court in today's case. Okay, so that is why it has the objective not to give legislators the higher privileges. Okay, so the objective is here 105 and 194. Okay, these two things are giving some privileges or special rights to the persons. Okay, that is why it is not giving anything to the legislators. Okay, so this is what you have to remember. Then what is the concept of parliamentary privilege? Parliamentary privilege means, privilege means is a special right? So special right in the form of immunity means you will be having some special safeguard or protection. So if you just want to understand the concept, you need to know from which country we have taken. Okay, it is taken from UK constitution, Britain constitution, the same concept of parliamentary privilege. So what is parliamentary privilege? It is nothing but a special right or immunity or exemptions, you can say, that is enjoyed by the two houses of parliament or the state legislatures and for their members also. So it is defined for 105 for MPs and 194 for state legislature, that means MLAs and MLCs. Okay, so under this, what type of privileges they'll have? Against civil liability. Civil liability means all the civil related cases only they'll have liability, but not with respect to criminal liability. Criminal liability means in case of any crimes if they do, so they can be arrested, but 40 days before, 40 days after, 40 days during the session, it will not be possible. Again, by taking the permission from the presiding officer only, they can do those things. Okay, so that we'll see then. Okay, but do remember one most important thing. So if you have seen, there is no codification of this parliamentary privilege, means it is not codified and listed down in one particular place. Sometimes, like you see in the Indian constitution, there is mention about 105 and 194, and some parliamentary rules and procedures have given birth for different parliamentary privilege, and sometimes Supreme Court judgments have given sometimes. Okay, so in this way, parliamentary privilege is not having one particular source, but from different sources we are having this parliamentary privilege, and there is no codification at one place. Do remember this. And second thing you have to remember is, as long as they're a member of the house only, they can enjoy this parliamentary privilege. If they lose their membership, these privileges will not be applicable. Automatically, they will be off. Okay, so here you can see parliamentary privilege, two types of privileges we have. Collective privilege means as the house, okay, they have some privileges, and individually also they'll have some privileges. Let's understand what are these type of privileges. Here you can see 44th Amendment restored the freedom of press to publish the reports, okay, but without prior permission. That means without prior permission also they can publish, but in case if any secret setting happens, at that point of time they need to take the permission of the presiding officer. Then excluding the strangers from secret setting. Okay, so these are the things collectively how as a house they enjoy. Make rules to regulate its own procedure, punish members or outsiders for breach of privileges or contempt, the right to receive information of arrest and detention of a member, sit and inquire into other things, and they can also call for the attendance of the witness and all. Courts cannot inquire into proceedings. No member of the proceedings can be arrested without permission of the presiding officer. Okay, presiding officer's permission is very much important. These are collectively there for the house. Okay, then individually they cannot be arrested during the session of parliament 40 days before or after. This is not available in criminal cases. Only in civil cases this permission has to be taken, but in criminal cases they can be arrested. Then freedom of speech in parliament, it is again not as I told you. Okay, why? Because all the time there will be clash between this 19 and 105. Okay, so whether the fundamental freedom of speech and expression or parliamentary privilege, which one has to be upheld, means doctrine of harmonious construction. This will be used by the Supreme Court. What is this meaning of the word doctrine of harmonious construction means? Supreme Court, okay, whenever there is a conflict between two provisions of the Constitution or two provisions of the statute, at that time Supreme Court will try to give balance, giving the balance for both the things. It will try to cause minimal damage to both. Okay, it will not give a judgment in a way that one particular thing will be upheld and another thing will not be totally made invalid. Okay, in that way they have to harmoniously construct the provisions of the Constitution so that both and its intentions will be upheld. Okay, so this is what doctrine of harmonious construction. Most of the times in these cases like 19 versus 105, these things will be there. And exempted from jury service, that means they can be refused to be as evidence before the court in case of any case. If they are part of evidence, they can even be exempted for jury service. This is an individual privilege there for the member of parliament and legislature. Then what did Supreme Court say in the current judgment? You can see here. It said corruption and bribery by members of the legislature erode probity in public life. Okay. So this have made a very good statement. Probity in, I mean corruption and bribery, if they are there, so it will erode probity. What is the meaning of the word when you study GS ethics, GS4 ethics? Okay. So at that time, you'll understand the terms probity, integrity, and all these things. Okay. Honesty, you call, right? Probity means nothing, having good moral values and principles. That is what we call honesty. That is probity in public life. Okay. In case if you're having corruption and all these things in the legislative aspects, okay, then it can erode the confidence and honesty in the public life. And Supreme Court has referred to a doctrine of stare decisis. So it is not inflexible rule of law. So what is this doctrine of stare decisis means? It is nothing but the legal meaning of this doctrine is to stand by things decided. That means already in this particular case, okay, so if you have seen the current judgment, it was referring to the previous PV Narasimha Rao's judgment in 1988, okay, 1998. So at that point of time, so you have to remember that the court is stand by the judgment, okay, so they're up, like they're respecting, they're upholding the judgment, but in the present context, okay, so when in the present context this thing appears again, so they think that they have to make certain changes, okay, so that is what doctrine of stare decisis means. The legal principle normally where the court will direct that it is adhering to the previous judgment while resolving the case with similar facts, okay, it is not disrespecting the previous judgment. That is what doctrine of stare decisis. Then judgment of this court in Narasimha Rao case granted immunity from prosecution to a member of legislature who is alleged to be part of bribery and all for anything he speak in the parliament or vote in the parliament, if it has any ramifications, okay, so if these things have any ramifications in public interest, probity, and parliamentary democracy, then it becomes a grave danger, okay, that is why it needs to be overturned. That is what Supreme Court has opined in the present judgment, okay, so this is what you need to know from the present context. Then let's see the practice question for prelims given yesterday in the previous video. With reference to tiger reserves in India, consider the following statements. First one, they aim to conserve both habitat and prey base of a tiger. That is correct, okay. So tiger reserves is mainly constituted for this purpose only. I told you in the previous video, we have 55 tiger reserves notified. Do watch the video in case if you haven't watched. And there is second statement, Sariska Tiger Reserve is the first tiger reserve in India. This is wrong because it is not Sariska. It is Bandipur in Karnataka. Bandipur is the first notified tiger reserve in India. Then third, Project Tiger aims for in situ conservation. You know, two types of conservation of biodiversity we have, okay? So you have in situ conservation and ex situ. In situ means on the place of habitat itself. That means that where the animal stays, there only if you are conserving, like national parks, wildlife sanctuaries, biospheres, tiger reserves, all these are in situ. And on the other hand, you have ex situ. What is ex situ conservation? Ex situ conservation means if you're changing the place of the animal, that means from the habitat, if you're taking it to some other place like zoo, botanical gardens, all these things are in situ, ex situ conservation. So this is in situ. This is also correct. This statement is wrong. Second statement. So if you eliminate 2, you have only one option, that is 1 and 3 only. Okay, in this way you have to arrive at the answer. Now, as we have come to the end of the video, let's see the practice question given on today's topic. So here you can see which of the following is or true. So first one, Constitution of India does not mention parliamentary privileges specifically in any articles. There may be contempt of the House without committing a breach of privilege. Okay. So among the given options, choose which one is true and answer in the comment section. Then as we see the mains question here, powers and privileges and immunities of Parliament and its members as envisaged in Article 105 of the Constitution leave a room for large number of uncodified and enumerated privileges to continue. Assess the reasons for the absence of legal codification of parliamentary privilege, how this problem can be addressed. This is the mains question given for practice. Answer and try to answer this question and let me know in the comment section. Then, as we have come to the end of the video, today we have seen what is today's landmark Supreme Court judgment with respect to legislators' immunity in bribery cases. And also we have seen what is the previous PV Narasimha Rao judgment given, why it was overturned, and also we have referred to the parliamentary privilege concept, what type of privileges members do enjoy, and we have seen the practice question for prelims and mains. Thank you for watching.